Hi, I'm Noah Weisberg.
And I'm Nick Esterbauer.
Welcome to Holland Estates. You're listening to episode number 591. How are you, Nick?
I'm fine, thanks, Noah. How are you doing? It's been a while.
Yeah, we are lucky ones to do the inaugural Holland Hall COVID podcast. We've decided as a firm to get these going again. And we thought today of a great topic of applications to pass accounts. And I think, Nick, look forward to discussing it with you.
Absolutely.
So I think we should start off, Nick, with the thought that applications to pass accounts, the duty to account is ongoing, whether it's an estate trustee, a guardian, or an attorney. And notwithstanding COVID, that obligation continues. And what we see happening now with our clients is through prior passings of accounts or just through disagreement of beneficiaries, fiduciaries, estate trustees, guardians, attorneys are coming to us saying, hey, I want to pass my accounts. What should I do given COVID? So I think that's what we're going to touch upon today. And hopefully we'll give our viewers and some listeners some tips and to help them understand the current procedure. So first scenario, Nick, is what should a estate trustee do if all of the beneficiaries are sui juris, if they're over 18 and mentally capable? Do they need to go to court?
So normally what we see in that situation is you serve all these beneficiaries with the application record to pass accounts. You wait until the deadline under the rules of civil procedure to file a notice of objection to accounts. If you don't receive any of those, you can typically go ahead and file what we refer to as a judgment record, which includes an affidavit from the fiduciary or their lawyer that states that no objections have been filed, or that any objections that have been filed have been subsequently withdrawn. And then you can typically file that record with the court and avoid the need for a formal court hearing.
Right. And just taking that one step back, Nick, if everyone's sui juris and the estate trustee prepares accounts, all you need to do is really get releases from them and your accounts are technically approved by the beneficiaries and all is good, right? But what happens is if a beneficiary doesn't want to consent, provide a release, or if we have, beneficiaries who aren't sui juris, is often when we have to initiate the application pass accounts procedure. So yeah, you raise a good point that traditionally unopposed judgments of passings of accounts, we could just get over the counter and all was well and dandy in our life. But with the court stoppage, we're kind of seeing a couple things. So the first thing that we thought that we would kind of discuss is what happens if you can't issue a notice of application pass accounts, right? One of the things that we talked about, Nick, and what we tend to be doing, if we think it fits the file, is to provide all of the beneficiaries with a copy of the application record, explain to them that this is the record you're going to be filing with the court when the court allows you to open it, when the court reopens, and see if you can work through objections with the beneficiaries without the need of the court to impose a timetable. And, we're seeing that as a way just to move files forward. And again, given the opportunity for the beneficiaries to review the accounts, and if they think that they're going to raise objections, you can at least get a couple rounds of objections in, again, which you don't need the court's approval to do. Counsel acting reasonably can figure out their own timetables and can certainly put together exchanges of objections and deadlines for that.
Yeah, so just ultimately with that approach, I guess, as you said previously, if everyone's sui juris, you may end up having them all sign releases and avoiding the need for the court involvement in the passing of accounts.
Right. And sometimes the estate trustee, the fiduciary, wants that added authority, wants that approval by the court. It may not always be necessary, but it certainly is if there's, an incapable beneficiary, if they're under 18 or if they're mentally incapable, you have to involve the OCL or PGT. So you can't do that in that situation. So you have to get a little bit more novel as to what you want to do. And one option you can do is mediation arbitration. Now that won't approve anything on behalf of an incapable person, but it can at least allow the parties to work through their issues, work through the objections. And when the courts do reopen, you could hopefully proceed on an unopposed or consent basis. Now, some courts, Nick, as we understand it, are still accepting consent or unopposed judgments. So if the parties are able to resolve all of their objections, there does remain the option of filing a consent judgment or an unopposed judgment and ask for the court's blessing on the judgment on passage of accounts.
That's right. And one issue we have encountered in that regard is that this typical deadline of 35 days before the hearing date indicated on the notice of application to file the notice of objection, I mean, we don't really know what's going on there. Limitation periods are generally told. Statutory deadlines are being extended during this health crisis. And it's debatable, I would say, whether or not it's open for beneficiaries to file a notice of objection at a later time once the courts resume their normal operations. So ideally, in that judgment record, you would be including the consent signed by anyone who's entitled to service of the accounts.
That's correct, Nick. Absolutely. I would be very reluctant to try to proceed with a judgment on passage of accounts unless you've shown that you've gotten the consents of all beneficiaries, everyone who may have a financial interest in the estate, or at least, providing, confirmation that they've reviewed the accounts and they do not oppose them. So, sometimes a PGT will just not oppose a judgment. They may not necessarily always consent to it. So really, Nick, I think just to conclude our thoughts, what we really wanted to cover today was that the requirement to maintain accounts always continues, and now council can still move their applications to pass accounts forward, notwithstanding the impediments that have been imposed by COVID. So on that basis, Nick, I think this concludes our podcast. Until next time, we thank you for listening. I'm Noah Weisberg.
I'm Nick Esterbauer.
Should you have any questions, please email us at webmaster@hollandholland.com or leave a comment on our blog. Thank you, Nick, and hope you have a great rest of your day.
Thank you.